Hello guys, and welcome to another episode of my lecture. Today we'll be talking about the case of Freeman and Lockyer versus BUCKHURST Park Properties. And to the fact of the case, the articles contained power to appoint the managing director. K, who was one of the directors, acted as managing director even though he was never appointed as such. He engaged the plaintiff, a firm of architects, to do certain work for the company, which they did, after which they claimed their fees from the defendant's company. The trial court held that K was never appointed. He acted as such to the knowledge of the board of directors, and thus the judgment was given to the plaintiff. The court of appeal in this case held that K had ostensible authority as he acted as managing director to the board of directors' knowledge. His act in engaging the plaintiffs was within the ordinary ambit of managing director's authority, and the plaintiff did not need to ask whether or not he was appointed properly. It was sufficient that there was power to appoint him as such under the articles. The defendant was therefore liable. On the issue of apparent and ostensible authority, which is where I want us to pay a lot of attention in everything that we've been learning so far, this is the case that clearly explains to us what apparent and ostensible authority will be. And do not forget, in the light of karma, I already explained to you that when we are looking at section 89A and B, they are all talking about, the liability of managing directors as well as the board of directors and the members in general meeting. Section 91 is talking about the liability of the company when it comes to acts of officers and agents. Now the question then becomes, has those officers been expressly or impliedly given authority to ask? If no, then you then go to the B. As those officers been given apparent or ostensible authority? But the question is, what to be regarded as apparent, what to be regarded as ostensible authority? And that is what Lord Diplock is coming here to explain to us. He is telling us that first, there is a need to distinguish between ostensible and actual authority, as actual authority is created by a consensual agreement between the principal and agents. In this case, the plaintiff company and K. But here there was no agreement between the plaintiff company and then K. K wasn't appointed, therefore we can't say that there was actual authority. An apparent or ostensible authority is a legal relationship created by representation made by the principal to the contractor, intended to be, and in fact created upon by the contractor, that the agent has authority to enter on behalf of the company into any contract of any kind within the scope of apparent authority, rendering the company liable to perform any obligation imposed by such contract. Now, I need you to understand that there are three people when we are talking about this concept. We are talking about the principal here, which is going to be the company. We are talking about the agent here, which is going to be the director or any other person in the company. And then we are talking about a third party. According to what Lord Diplock has said in this case, he is telling us that for there to be ostensible authority, it means that the principal must have put out the director or any other person in the company. He must have put that person out, that this person represents the company. The third party must have believed such representation, so much so that the third party entered the contract believing that that particular director or any other person in the company has authority to act on behalf of the company. Apparent authority may be by representation or by conduct, which would mean that the company must have permitted the agent to act in some way in conduct of the company's business. Since the principal here is a corporation, its capacity is therefore limited by the memorandum and articles and the fact that the company can only make representation through its agents. Any act which the principal company permits its agents to do must be permitted by the constitution, that is the memorandum and articles themselves. Do you understand? For there to be an act that the third party is saying that the company had told the agent to do, that act must be such as to have been permitted by the primary rules of attribution, which is the articles or the memorandum. Also, company must be able to delegate authority to agents in its constitution. Secondly, company can only make representation through its agents, that is, those making the representation must have actual authority from the corporation, which must have been conferred on them by the articles or by the memo. I already explained this in previous cases when I told you that for a third party to say that an agent has authority, it means that the articles or the memorandum must have conferred the authority on the board of directors or on a higher person, and also the articles or memorandum must have also conferred the authority to delegate such power. Not only must the power have been vested in a higher person, the power must also be such that it is delegatable. If the power is such that it is not, then the agents cannot have such powers, so much so as to bind a third party, so much so as to cause liability for the company. Do you understand? Now, there is a very important thing that I want us to also note when we are talking about this particular principle. Look at this statement. Lord Diplock said, company can only be stopped where the memorandum and articles make contracts or travails or prohibit delegation of such authority to agents. Now, I want us to juxtapose this statement. Company can only be stopped where memorandum and articles make contracts or travails or prohibit delegation of such authority to agents. Now, you know that statement is two-legged. Let us take the first one. The first one tells us that the contract must have been ultra vires. Now, when we go to section 89, section 89 tells us that a managing director, the board of directors, or members in general meeting will be liable even if, when we go to B, even if the business carried on by the company isn't part of the business that has been stated in the company's memorandum. Where a managing director acts, where the board of directors acts, or where the members in general meeting acts, and their act is such that they carried on a business that was not authorized by the memorandum or the articles, they are still not going to escape liability. According to Lord Diplock, which is the common law rule, the company can only be stopped, which means that the company can escape liability here. In this case, where the contract is ultra vires, if you look at the company's memorandum, but in our KAMA, where it is ultra vires, the company will still be liable. But that is for section 89B. Don't forget, I told you that section 89 is only for the three organs. Now, when we check section 91, section 91 has no provision that talks about the business of the company. Would that therefore mean that where a person acts on behalf of the company, either where he has been expressly authorized or impliedly authorized, or where he has been given ostensible or apparent authority, can we say that if the person does not act in accordance with the business of the company, then the company would not incur liability? Do you understand? Because they made it express in section 89A and B, but they did not make it express in section 90. Therefore, what do you think about it? I would like to give everybody this as an assignment. Then we go to the next point, where we say prohibit or delegate such authority to agents, which is what I've been telling you. Not only must the article provide that such power is given to an higher authority, either the board of directors or the managing directors or members in general meeting, it must also give that particular organ the power to delegate. Where the organ has not been given the power to delegate, even where there has been an ostensible delegation or an apparent delegation, the company, according to the case of Freeman and Lockyer, will still not be liable. Let's go to the 4 rules that were laid by the case of Freeman versus Lockyer. For a third party to rely on apparent or ostensible authority, 4 conditions must be fulfilled. Number 1, representations were made to the third party that the agent had authority to enter into contracts of the kind sought to be enforced. Number 2, the representation was made by one with actual authority to manage company's business. Number 3, that the third party relied on such representation. Number 4, the memorandum and articles did not prohibit contract of such kind or prohibit delegation of authority to enter into such. So basically, when we follow this rule in Freeman versus Lockyer, they gave us 4 conditions, and then I called my own 4 conditions PART. P-A-R-T. The first one is that there must not be a prohibition. Do you understand? Now, the memorandum of association and the articles of association, they must agree that the power has been given to a person with higher authority. Do you understand? And that power is delegatable. Where there has been a prohibition on the power given to that person, or where there has been a prohibition on the delegation of that power, then this rule will not apply. The first one is prohibition. The second one is actual authority. The person that has been given that power, either by the memo or by the articles, had actual authority to act. The first one, the person must not have been prohibited to have the authority, as well as been prohibited for delegation. The second one is that the person must have the actual authority to act. So that's P, and then that's A. Then the R is that there must have been a representation by the person who has authority, that's the actual authority to act, that has been given by the memo and the articles without being prohibited. The person must have made a representation. And then the last one is that such representation must have been relied on by third party. Very easy. P, no prohibition. A, actual authority. R, representation. T, to a third party. Once you have the PART rule, then you understand the case of Freeman versus Lockyer. So you see, we are done with section 91 and we are done with section 89A and B. But very interesting, we are going to the next rule, which is the double rule of ratification, which is introduced by our Kama. So let us go to the double rule of ratification and what does this say? See you in next class.